All right, all right. Peace and love. Peace and love, family. It's your brother Isaiah tapping in. Let me get this right. Tapping in with another one for the conscious brothers and sisters in the conscious community. Keeping the struggle because we know it's through the struggle that we grow. Also, I like to say that it is a slow process for progress and that the race is not to the swift, but it's to those that remain dutiful. So make sure you stay in this journey for the long haul. Y'all already know that I don't offer legal advice. I'm not a legal counsel. I'm not an attorney. Not any of those fictitious titles. I'm your brother sharing with you education and information about my walks, travels, throughout my journey called life. I like to extend these honors to you. When you're honoring man, woman, you're honoring yourself. All right, so today I want to go over a little bit about an assignment. Assignment of contract rights. All right, this is a learning objective. You understand what an assignment is and how it is made. Number two, you will recognize the effects of the assignment. Number three, you will know when an assignments are not allowed. And number four, you'll understand the concept of assigner's warranty. All right, so the concept of a contract assignment of contracts rights. A contract creates both rights and duties. So whenever you enter into a contract, it's always going to create rights, but it's also going to create duties pertaining to those specific rights that the contract allegedly gives to you, right? Now, the party entitled to receive the benefits is called the obligee, right? That person may transfer their rights to another person known as the assignee. And the act of transferring the right is called an assignment. So let's go real quick. We're going to look this up. Okay. Legal definition of obligee. Okay. Now, okay. Now, an obligee is a person or entity. If you notice, most of the definitions would always say person or entity because the person is the individual, which is a legal person. And the entity is any corporation because most men and women either we're acting as a person or either we are a registered officer over our person as an entity. Because usually when we're not registered as a business, then we're acting solely as the person. But when we're registered, we're acting for a registered entity, right? So the obligee is the person or the entity to whom an obligation is owed, right? So this term is commonly used in contract law, where the obligee may be the creditor or the promisee, right? For example, in a surety relationship, the obligee is the creditor who can enforce payment or performance by the principal, right? Or surety. In family law, the obligee may refer to an individual receiving child support or alimony, right? So we want to make sure we really understand who the obligee is. The obligee is a person to whom a legal debt or other obligation is owed, right? The obligee would be the individual who would be in receipt of child support. alimony, or both. In civil law, an obligee may be in receipt of the proceeds from the contract or promissory note. Other examples of obligees include insurance policyholders and creditors, right? See, so you can't just read the first definition and think you're going to understand what an obligee is, because you might think you understand, but it might throw you off, right? So the definition, an obligee, written in plain English along with the examples, right? The term obligee is commonly used in contractual law, referring to the party receiving an obligation from another party. So an obligee is somebody receiving an obligation from another party. This obligation is typically enforced by the legal agreement, and the obligee is entitled to a specific performance or remedy from the obligor, right? If they fail to fulfill their obligation, the term obligee comes from a Latin term, obligor, which means to bind, right? So the obligee is usually the lender or the creditor, right? So let's go back, right? And the obligor is the debtor, or what we call the principal, right? So when you're reading this, right, you got to really go into it to make sure you understanding the specific roles of each party, right? Let's go back real quick. What was I at? Right here, right? So when it says, right here, when it says the contract creates both rights and duties, the party entitled to receive the benefit is called the obligee, right? And that transfers their rights to another person known as the assignee. All right, the assignee is the man or the woman receiving a contract. The obligor is the entity or the principal on the contract. The act of transferring the rights is called an assignment. Once the transfer occurs, the original obligee, right, which is the lender, now the assigner steps aside. So at the very beginning of the contract, remember we said that, let me go back real quick just to show it to you so you don't forget. Very important. An obligee, right, because we're talking about the obligee, is a person or an entity to whom an obligation is owed. When you owe something, that means that you're in debt or you have a due obligation to another person. The term is commonly used in contract law where the obligee may be the creditor or the promisee. Okay? Now, once that transfer occurs, the original obligee, now the assigner, right, steps aside, and the assignee acquires the rights to receive performance directly from the other party to the contract, the obligor, right? In short, the assignee stands in the shoes of the assigner, right? And assignments are very common in business transactions. Banking, a bank may assign its rights under a mortgage or a loan to another financial institution. Accounts receivable financing, a business may sell its outstanding invoices to a factoring company for immediate cash. Sell its invoices for cash, okay? Leasing, a tenant may assign the rights to occupy the premises to another party, right? With the landlord's consent. So you have the rights to occupy the premises because of the lease, but you can assign that right. Instead of you being the occupant, you can assign the right to make another person the occupant, which would make them responsible for the payments of the lease agreement. All right. Method of assignment, manifest in assent, right? For an assignment to be valid, the assigner must clearly express the intent to transfer rights immediately. The intent must be definite and present, not a vague promise to transfer later. So you got to manifest your intent, your assent, your approval. So, because usually when you get approved for a loan, you are receiving balances that are due to you. They usually come to you as due balances to you, but you got the rights to redirect them to somebody else rather than them being directed to you to where you'll be responsible for the balances if they're not paid. So when something is due to you or is being directed to your order to where it runs to your order, when something is payable to your order, it's payable directly to you. When something runs to your order, meaning it is due to you. When I say this is due to you, that means that it's running to your order, meaning you have the rights to order the payment or the due balances. When something is, listen, when something is payable to you, then that means you are the holder in due course, that the course of all amounts are payable to a specific party who is the holder of that right. When something is due to you, it runs to your order, meaning you have the rights to order that payment for you because it's due to you, but you're not ordering the payments. Because when something is due, it should be ordered or an order to the person it's due to. All right. Now, a valid assignment example. I hereby assign my rights to collect $5,000 from James under our contract to Maria. Invalid promise. I will assign my rights to you next month. This is a promise to assign, not the actual assignment. Acceptance and revocation. Most agreements require no special acceptance, especially when the assignee gives consideration, right? Something of value. So the assignee, the one receiving the contract from the one assigning it, right, receives something of value in exchange for the assignment, right? In those cases, the assignment is binding and cannot be revoked without the assignee's consent. Issue arises mainly when gratuitous assignments, those given as gifts, those are usually revocable unless the assignee accepts the gift, right? Or the assigner provides written notice of the assignment. Example, John assigns his rights to collect rent from a tenant to his brother as a gift. Unless his brother accepts or receives written notice, John may revoke the assignment, right? Notice to the obligor. Once an assignment is made, the obligor, the party who owes performance, should be informed so that they know where to direct their performance. Now, let me explain to you. Say you apply for an obligation for a personal loan, say through a bank. The bank approves you for the loan. What does that mean? That means that the bank is what? Right? The obligee is the one who the obligation is due to. It is owed to the bank. The bank is the creditor creating the obligation, and ultimately the obligation is due to the bank. Why? Because according to the Fair Debt Collection Practices Act, it says the creditor is the one who creates the debt, and ultimately the obligation is due or is owed to the creditor, right? So when we reading this, right, when we talk about an assignment being made, and then the obligor is the party that owes performance, right? Should be informed so that they can know who to direct their performance to. Strictly speaking, notice to the obligor is not required for an assignment to be valid. However, whether or not notice is given can have serious consequences. If an obligor has no notice of the assignment and performs by paying or delivering to the assignor, the obligor is discharged. The obligations has been satisfied even though the assignee did not receive performance. In that situation, the assignor cannot keep the benefit he owes it to the assignee, right? So, but once the obligor has notice of the assignment, the rules change. So what this is saying, say you apply for a loan and it get approved. Say you get approved for $50,000. So $50,000 is the amount the company owes you to satisfy the credit agreement for you to receive credit. So until you receive that $50,000, they are an obligor, meaning that they have an obligation to you for approved credit. Now, we wasn't taught this, so we always default because we don't know they're supposed to be giving us actually what we get approved for, okay? So once you get approved and you sign the contract, the company is on the hook. They are the obligor. They are the ones you are the obligor when you first sign because you are making a promise to repay something that they are promising to pay you. So as long as you sign the contract, they are the assignor and you are the assignee. When you sign, you accept stepping in their shoes, right? So now they get off the hook and you become the new obligor, right? Because you're accepting an assignment of rights and titles from the person who is actually really responsible. The title holder, the original creditor, is the one responsible to provide the amounts in the contract. But at the beginning of the contract, he assigns the title and the rights, giving you the right to purchase it. His sale for purchase transfers his obligation also. So even though he owes performance, when you sign, you take over his responsibilities and he gets his obligation is set to the side. Now you have accepted stepping in his shoes to pay what he promised to pay. So now he was the original promiser to pay. But when you took over the contract, you gave a re-promise, meaning you re-promised to pay the same thing he was promising to pay. But really, he was promising you that first. But when you sign, you promised to pay it back. But so both of y'all are both making these promises to each other. The lender is promising rents, installments, or whatever the contract calls for, and you're signing and you're agreeing to pay those installments to the lender. But before you can pay, you got to actually receive what the agreement approved you for. So it's y'all both are dependent on each other. You're dependent on the amounts that he promised you, and he's dependent on the amounts you promised to pay. So y'all both are dealing with each other's promise, right? Now check this out. Now, when you sign the contract, you become the assigner. The original assigner, well, he's the original assigner. When you sign, you are the assignee. But when you want to assign your rights as a party to the agreement, you become an assignor for your own benefit. So what I'm saying to you is you are in the position of the obligor when you hold liability. If you were to accept the contract from the lender and then you were to assign that contract to somebody else, the lender will remain the debtor. He will remain the obligor because obligation is the lender's obligation to provide the due balances that you are responsible to pay. When you apply, he approved it. So when you want to pay it, you got to assign it or pay it. And whenever you assign it or pay it, whoever you assign it to, once they receive your rights on that contract, they can go to the lender and say, hey, look, he assigned his rights to those rents to us, and we're sending out a notice of collection to collect on behalf of Isaiah Bay all rents that are due and payable under the lease agreement in which he assigned to us. See, when I assigned it, I was giving somebody else the rights to act as me as a debt collector and collect my debt for me. You see what I'm saying? Because the debt was an obligation owed to the creditor who owed me performance. See, when they say that the obligation is owed to the creditor, it's owed, the performance that you gotta perform is owed to him. You can't perform without the creditor, without you owing the creditor his responsibility to help you perform, because the way you gotta pay through your creditor. Your creditor is the one who provides you the approved credits that the agreement said that you was approved for. He's the one holding back those electronic credits. And when you want to use them, you got to go through that creditor, right? So when you assign a contract to somebody else for collection and payment, then you got to put the obligor on notice. That's what this is talking about. So you got to tell the obligor. Who is the obligor? If I promise you rents on a lease and you accept the lease and assign it for collection to your bank, the bank is going to come after me for the collected rents that you assign. Meaning you got approved for rents and you assign them to me as the bank, your financial institution, for collection and payment, for me to collect on the payments that are due on the lease. So once you do that and you give me the lease, now I hold your title. Your title is your rights to the amounts that the lender offered. Now that you assigned it to me, I can collect on your title, your rights, because you're giving me the rights to enforce the lease that the lender provided you with. By assigning it to me for collection, then that means that the rents had to be unpaid. At the time you received the lease, your rents were due. They were not paid yet. So if you want them to be paid to you, you got to assign them to another party who can collect them for you. That's why they say that a creditor usually collects obligations in the name other than his own in order to indicate that a third party is the one collecting, but it's really you collecting through the bank. You see what I'm saying? Through assignment of rights. Understand that, right? Now check this out. If the obligor has no notice of an assignment and performs by paying or delivering to the assignor, the obligor is discharged, right? The obligation has been satisfied even though the assignee did not receive performance. In that situation, the assigner cannot keep the benefit. He owes it to the assignee. But once the obligor has noticed that the assignment, the rules change. If the obligor still performs to the assigner, that performance does not count, and the assignee can recover directly from the obligor or the assigner, right? This could place the obligor in an unfair position of having to perform twice, right? So this is what we talk about when we say that they double dipping, right? Because once you have got approved and the contract has been assigned, right? The rules change if the obligor still performs to the assignment. So if T-Mobile assigns its rights to you as the obligor, and it gives you the rights to receive payment of all amounts due on the contract that it assigned to you, and once you sign that contract and accept the amounts of as credit under the agreement, and then you give that contract back to T-Mobile, and then they keep collecting from you when you're the assignee, and the assignor is still collecting from the assignee. The assignee is the one who's supposed to be collecting. If I assign something to you, I'm giving you the rights to collect what I originally had the rights to collect. So if I'm the lender and I had the rights to these amounts and I assign them to you, that's because I'm giving you the rights to step in my shoes and enforce the contract with me to accept what I'm approving you for. But in order for you to get it from me, you got to accept my contract and enforce my contract with me. You got to say, I accept your agreement. I accept to enter into a contract with you and receive these due balances. And as consideration, I make them all payable to your order, demanding that you process each payment in accordance to our contract. So once I do that, that puts you in a position of performance of what you originally promised to me. Now we have reciprocal agreements. You see what I'm saying? We're both dependent upon each other. I'm not trying to pay you twice. Because I've already, what do you mean, brother? I said, how you paying them twice? How you paying them twice? Okay. Let me show you something. I'm going to have to show you, right? This is the only way you're going to get it, right? Check this out. Make sure y'all like, share, subscribe. It's your first time. Make sure you hit that like button, man. Y'all make sure y'all get that like, get them likes up, share. Make sure you participate, comment. If you got any comments, man, get involved. The more rhythm I get, the better it is, man. So y'all participate, rock with your boy, man. You know what I'm saying? I'm rocking with you. You need to rock with me. All right. So we're looking up the legal definition of, hold on, what was I looking at? All right. So we're talking about the obligor having to perform twice, right? All right, so to perform twice is to receive a contract, and then once you receive the contract, you assign the contract to the lender, and then instead of him crediting you for the assignment, he continues to charge you every month as if you didn't already do an assignment of the original contract, meaning that at the time when he received it, it was an assignment. So it's already been, you already paid once, right? So that's what I was going to show you. How do you pay already, right? How does consumer pay? Look, now check this out. All right, because if you don't know this, then you ain't gonna never know if you bought something. So the legal term, the word purchase, generally refers to lawful acquisition of property. So when you purchase something, there's a lawful acquisition. Maybe you don't know what an acquisition is. Maybe I need to look up the legal definition of acquisition, and that'll help you get a better understanding, right? But the word purchase generally refers to lawful acquisition of property through a transaction. So when a transaction takes place, usually there's a lawful acquisition of property. Somebody signing and receiving a right to become the owner of property, right? As opposed to inheritance or other forms of descent, right? So when we say the legal definition of purchase, all right, so you can purchase something by doing an acquisition of property. So what's the legal definition of sale? All right, so the legal definition of the word sale in the United States is a legal contract. So wait a minute. Wait, don't we enter into contracts every time we need something? Hold up. So we just looked up acquisition was to actually take property. Now we're looking up the definition of sale because we want to know how we're buying something and how it's being resold twice, right? Now in the US, a sale is a legal contract in which one party, the seller, transfers ownership or title of property or goods to another party, the buyer. Wait a minute. So wait a minute. So you mean a contract is a sale? So if I apply and put in an application and they transfer, they just sold that to me? So I'm applying for a sale. Oh, wow. Wow. So you're applying for the lender to sell you a right to do something, right? So a sale is actually a contract which represents the title of the agreement, which covers all amounts, all obligations, is known as the title document. A sale is whenever that document goes from the seller to the buyer in exchange for a price. Now, this price is the key. In exchange for a price. All right? Usually money, but sometimes other forms of consideration. The transfer of title is the key. legal element that distinguishes a sale from other exchanges. So that's why the UCC says that a UCC is ineffective and unenforceable against a title holder when it comes to certain laws and regulations that already have been approved by public law. What if I got title? Title represents ownership and rights and interests. What do I need a UCC for if I already got a perfected interest? The title is in my name with my signature. That means all I got to do is be competent enough to read and understand and financially interpret what it's really saying. And if it's defaulted and it's being misrepresented by any creditor, I could correct that, but I got to be smart enough to do it. Smart enough, competent enough. Okay, let's go down a little bit. Core legal elements. For a sale to be valid, there must be generally four essential components. Competent parties, like I just said. You got to be competent. You got to know when you're buying something. You got to know when you paid for something. If I deliver a lease to you and you bought the rents already, how would you prove to me that you already bought those rents that I'm trying to make you pay me again every month? How do you prove to me that it was already bought or purchased by you? Because you got to be competent. A valid objection. The property or the goods being sold must exist, and there must be the subject of the agreement, meaning that the rents exist in the lease, and the lease was the reason why I get to claim the rents. I purchased the lease with due rents, and I'm demanding that you acknowledge me as the one entitled to use the rents that I purchased in my lease. You see what I'm saying? But if you're not competent, you can't do that. You can't deliver the agreed price. Why? Because you don't know how. And an agreed price. What did we agree to? We agreed that I will repay rents back to you. You agreed that the rents were part of the lease, and that was part of my loan that was applicable to my lease, and I agreed to the same price to pay you back. There must be a mutual understanding of the price or the value exchange. So that means that I gotta acknowledge. I gotta let you know what I'm agreeing to. I gotta let you know that I've accepted what you provided and what that is and what I'm paying and how I'm delivering it. If you don't do that, then you haven't made a meeting of the minds. Understand what I'm telling you. Mutual consent. Both parties must agree to the terms, and certain acts like delivery or registration must be completed to finalize the sale. To finalize the sale? Man, I can't make it up, man. I can't make it up. I can't make this up, man. All this right here, this is the reason why people can't get nothing paid. This is the reason why people can't understand the contract, because all these things that it's talking about, these four elements, these are the four elements that most people are incompetent of, that they do not understand. They do not understand the agreed price. They do not understand mutual consent. They don't know what a valid objection is and when to object, and nor are they competent as a party to the agreement to purchase something that's being sold. See, when you lack these things here, then you just subject. You're a public charge. You know what I mean? Because you don't understand what's going on. All right? Go back. Let's go back. Go back. Keep going, baby. Keep going. Now, so because of the risk, an obligor who receives notice of an assignment from someone claiming to be the assignee has a legitimate concern. How do I know assignment is real? After all, anyone can show up and say, I'm the assignee of your contract with the bank. From now on, pay me the $500 a month, not the bank. And the law recognizes this concern. So if I'm the assignee of a lease where I'm entitled to due rents of $300 every month from my lender who has approved me for the rents in the lease, and I want to collect those rents as part of our agreement, I can assign that lease to another institution like my bank as my paying agent to collect all the amounts that are due and payable under the lease. Once I assign it to them and they receive and accept the assignment, I put the debtor on notice. Who is the debtor? The debtor is the one who provided the lease to me, who is responsible as the creditor, in which the obligation is ultimately due to him. So once I assign it, I put him on notice of his obligation and who he's supposed to provide those approved rents to every month for my personal, my family, and my household benefit. Now look, check this out. Let's keep going. When a right is assigned, the assignee does not receive anything, right, more than what the assigner had. Instead, the assignee effectively stands in the shoes of the assigner. So if I'm the assigner, right, I'm assigning only what the corporation gave me. So if T-Mobile give me an installment contract and I step in the shoes of an assigner, at that moment, I'm the assignee. When I receive the contract, I'm receiving it as the assignee. I'm being signed the same rights that T-Mobile got. They had their original creditor. They assigned it to me. Now I become the assigner of their right when I sign. Now, when I assign the contract, now I'm the assigner, right? And what I'm assigning is whatever rights were assigned to me as the assignee. They assign all these balances to me as the assignee. Who assigned these rights to me? The creditor. The original creditor made me assignee of his right, of his obligation. He had an obligation to provide rents on the lease. He assigned that right to me, and I accept that right that he's assigning, and I'm assigning that right to somebody else to collect on those rents that he assigned to me. Once they receive my assignment, they can now go after the original creditor to collect on the original promise made. Me, as the assigner who assigned my rights to another assignee to collect my right to receive rents, now I have to put the original creditor on notice of my assigned right, saying that I no longer hold the rights to the rents in the lease, that it was assigned to another, and that you can make your payments to him at this location and address. Okay? That's an assignment. That means that the original party remains on the hook as long as you don't step in his shoes and end up replacing his obligation of performance. As long as you can continue his performance, meaning he's making an offer and you assign his offer, he's still liable for it. If you keep his offer, you switch roles with him and you become the new debtor to perform what you accepted as the new assignee. You became the assigner. See right here, let me show it to you. How did you become responsible for the lender's obligations? Right here. It says when the right is assigned, the assignee does not receive anything more than what was assigned. So if they assign a contract to you, you don't receive any more rights than whatever that contract is assigning to you. Instead, the assignee effectively stands in the shoes of the assigner. So once you receive a contract, you become the lender. Okay? You become the lender. Okay? You step in his shoes. This means that the assignee, which is you, the one who's receiving the lender's contract, acquires all the rights of the assigner that the assigner had against the obligor. So now you step in the shoes of the lender to enforce your rights against the obligor. Now we know that the obligor is the United States government. The government is the obligor. We already know that these are United States contracts. So we already know who the real debtor is, right? But also takes those rights subject to any defenses or claims the obligor could raise against the assigner. So this is the holder in due course rule. If you've been studying, you should know the holder in due course rule. No matter where you read it at, you should know what it is, and you should be able to identify it whenever you're reading any kind of legal mumbo jumbo. You should be able to say, okay, that's the holder in due course rule. Because it says, subject to any defenses and claims that the obligor, well, that's the same thing the holder in due course rule says, that nobody can hold a consumer contract without being subject to the claims and the defenses that the consumer has against the original seller. The seller is the assigner. The signer is the seller. The creditor, the seller, and the assigner are the exact goddamn same person. Why you can't understand that? In other words, if the obligor have refused to perform for the assigner, for the lender, the obligor can refuse to perform for the assignee on the same grounds. The assignment does not improve or enlarge the underlying rights. It simply transfers them. So what it's saying is, if I dispute with the original lender and he assigned it to another and they're trying to collect on their accepted rights to receive payment, then I can assert those same rights against them that I assert against the original lender, right? It says that the Uniform Commercial Code reinforces principles in the context of accounts. The assignee is bound to all terms of the contracts between the debtor, obligor, and the creditor, assigner. So whatever agreement me and the original creditor had pertaining to the proceeds, pertaining to any rights, interests, or titles that I have in the product, even if he sold it, even if he transferred it without any claims or attachments by me to it, because I didn't know I was supposed to claim title over my property so nobody else can take it away from me, and I gave it to a lender without any substantial claims or defenses against any transfer of my rights, and he transferred a right, I still can make that claim against any other holder because the original contract holds the rights that I originally had, which are originally enforceable upon redemption. That's why when you redeem, you bring back every right you originally had. If the rights were for you to receive proceeds, if the rights were for you to be paid, if the rights were for you to receive benefits, once you say I redeem this contract, then all those rights come back. Everything that you supposedly lost comes back to you. Redemption, just like Jesus. You're redeeming yourself. From what? From sin. What's sin? Debt. What is sin? Sin is debt. Wait a minute. You don't believe it? Let Brother Isaiah put you on game. Yeah, I'm going to put you on game, baby. Look. Oh, look. Y'all going to quit playing with me. All right, so let me explain it to you because it's a little bit different. But I gotta explain it to you in a way that you understand it. So in the Christian teaching, sin is often described metaphorically as a debt, right? Owed to the God, right? All right. So the God could be you the spirit, you the God consciousness. And the debt is what the flesh owes, but it owes it to God, which is the consciousness or the one that's given the value in the world to the person. All right. That's one way of looking at it. All right. I'm just trying to show you. But sin is for you to pay something that you should be receiving, right? Sin is often described as a debt owed to God. All right. And this is not literally financial obligation, but a spiritual one. Consequence of failing to meet standards of holiness. So, consequences of failing to meet standards of holiness, you're supposed to be competent. You're supposed to be living in accordance to what God prescribed for us to live. We're supposed to be acting as men and women. If we're assigned persons as legal identity, we're supposed to be competent enough to manage our persons. Okay? When we don't do things in accordance to what's prescribed legally by law, when we do things outside of divine law and we allow the world to induce us to other things, that's why I say be in the world, but not of it, because you're supposed to be living by holy principles that automatically supersede over state law, federal law that automatically lets you know that you're on the righteous path. When you go contrary to what's right, then that's when sin come in. That's when all this stuff come in. When you go out and you go get a driver's license and you break the law because it's a sin, it's a violation to drive. You ain't supposed to be driving. That's why you got to get a license, because it's illegal to drive. It's illegal to do business. It's illegal to do business without a license. Don't you understand that that's a violation? That you're going against God's law. Anytime you do business, you're going against God's law. Anytime you get a license, you're going against God's law. You're breaking divine law and you're accepting benefits from the state in order to do something that would be considered unlawful. I can't make it up. And the wages of sin is death, because when you in sin, everything you do is unconscious. Meaning you don't even know what you're doing. You eating the wrong stuff, you drinking the wrong stuff, you taking in the wrong information, you live in sin, you live totally outside of divine principles. You're a transgressor. All right? That's exactly what that is. Right? Now, the Uniform Commercial Code 9318-1 reinforces principles in the context of accounts. The assignee is bound to all terms of the contract between the debtor and the obligor and the creditor and the signer. A dealer sells a car to a buyer under a contract where the buyer pays $300 per month. So wait a minute, this is the trickery. You got to listen to the words. So the dealer sells a car. How did the dealer sell the car? Because we know dealers don't sell cars, they sell contracts. So it says a dealer sells a car to a buyer under a contract. So without the contract, the dealer can't sell the goddamn car. Understand what it's saying to you. They give us the answers, we just don't know how to read. We don't know how to read to interpret or to comprehend. So a dealer sells a car to a buyer under a contract. So what the contract was the sale of the car, because the car was sold under a contract. But how many people do you think will read this and know that the dealer is selling a contract? The first thing they see is he sold a car, and that's what they go with. Oh yeah, I'm buying a car. Are you really? Are you really? Okay, you buying a car, you're right. I'm gonna let that go. But I don't believe you're buying a car. I believe you're buying a contract. And the contract, once it's paid for, the car is yours. All right. The dealer sells the car to a buyer under a contract where the buyer must pay $300 per month, and the car comes with a $50,000 mile warranty. Before 50,000 miles, the car breaks down. The dealer refuses to honor the warranty. The buyer spends $250 on repairs and deducts that amount from the installment payment in practice known as set off. So set off, another way of setting off is when you have a right to receive the same amount the lender is demanding that you owe, if in fact you already have a secured interest in the same amount by way of purchase. Say I purchase an installment contract from a lender as an extension of credit, and the lender starts trying to collect the installments from me. I can dispute the lender's demand for payment by acknowledging that the installment was already bought and that the due balances that he's collecting on were purchased along with the installment, and that those amounts are actual credits that's already been tendered to the lender for application to be credited to the account. I'm not giving you're not supposed to be collecting those due balances. When I signed the loan over to you, that was a transfer of title. That was an assignment of rights, meaning that I assigned that right already to you, and I issued those amounts along with the pledge. So those amounts are already paid to you. Now, why won't you just accept and apply them? Why are you trying to get me to repay you again in order for you to receive payment when all you got to do is apply the amounts that's already been tendered along with the pledge? See, but we don't understand that, so we can't get a set off. Set off is when you receive the actual value from the contract to set off the lender's obligation. All right, later the dealer assigns the contract to the assignee, that's the bank. Because the assignee stands in the dealer's shoes, because when the dealer gives it to the lender, then the lender, now the bank can come after you if the lender is saying that his amount was unpaid, that you were supposed to pay the dealer the amount that you were approved for, You defaulted. The dealer assigned it to the bank. The bank stands in the dealer's shoes. Now the bank is billing you for the unpaid balance that you promised to the lender, but which the lender should have deducted as an amount of credit. He should have never even charged you for it. If you would have used that amount with the lender, you would have got a deduction. You wouldn't have even got charged because it was an extension of credit. You already got an approved balance with him. And if you use that balance, he got to deduct it, not charge it. Understand? Or he charges it by deducting it. That's the way it goes because it's already approved. You already got that amount with him. So basically, if you get approved for $50,000 credit with me, you got a $50,000 check over here with me already. I just approved you for 50 grand. So I got a $50,000 check over here that you are worthy of. Whenever you claim it, whenever you say you want it or you want me to release it, then I got to release it to you. Why? Because you already got approved for it. So I'm already 50,000 in the hole with you for the approved balance that my institution received for you for credit. So when you got approved for credit, we received the advance payment of 50,000. So now we have an obligation to you for that amount. If you were to accept it and agree to use it with us, we would have to deduct it because that's the only way we can pay you. That's the only way we can pay you is by deducting it from what we already hold. See, but if you don't know that, you're going to default. Why? Because you don't know what's going on. You don't understand the contract, right? Now, the shoe rule that an assignee takes only the rights that the assigner had does not apply in two situations where a negotiable instrument is transferred to a holder in due course, or when the obligor has waived defenses against the assignee. Even then, important limits apply. Certain real defenses like duress and fraud always remain available in the consumer protection laws, the FTC, Federal Trade Commission. Why do you think the Federal Trade Commission, they talking about that with a consumer? Because you're in federal territory. Anytime you're in federal territory, you're going to deal with the Federal Trade Commission. You're going to deal with the federal agencies like the Consumer Bureau of Protections, and you can file a complaint. Why? Because you're already in federal territory. You're receiving federal contracts. You just ain't paying attention. You filing complaints with federal agencies, but don't know that the contract is a federal agreement. Like that man, you got to be out your damn mind if you don't understand. You think just because you're in the state of Missouri, you don't know that's a federal state, man. That's federal. All right, I'm done talking about it. When an assignment are not allowed, the general rule is that most contracts rights can be assigned, but there are important exceptions designed to protect fairness and prevent abuse. Below are major situations in which the assignments are restricted or forbidden. Material changes in the duty of the obligor. An assignment is ineffective if it would materially alter the obligor's duty. So if the corporation duty was to provide credit to me every month and I assign my rights to the Treasury for collection and payment, as long as it doesn't change his duty to provide the same amounts that he would have had to provide to me, then the assignment is good. But if I assign it in any way and it makes him have to do something other than what he originally had to do, that's an ineffective assignment because it's not in accordance to what the agreement was. You can't make him perform outside of what he promised. So any assignment would have to be to the promise of the obligor. Who is the obligor? The obligor can be anyone. The obligor can be you. The obligor can be the lender. The obligor can be the United States. The obligor can be anybody assigned with a duty of performance who fails to perform. So just because performance was put upon you, that doesn't make you an obligor. That makes you an assigner or an assignee or a specific party who has a responsibility. When you don't perform, you become a goddamn debtor. That's when you become the debtor, because you accepted liability when you could have transferred the right to have somebody else become liable to performance. Okay? Examples. Now, let me go down. Assignment of personal rights. Contracts involving personal rights can be assigned because it is a matter to the obligor who receives the performance, right? A student agrees to research work for a professor she admires. The professor assigns the contract to another colleague whom the student dislikes. The assignment is invalid. An insurance company issues a policy to a careful 65-year-old driver. He cannot assign the policy to his reckless teenager grandson because the issuer contracted based on his personal risk profile. Personal services and most tenancy agreements fall under this category. All right. And then they got like where the assignments are forbidden. And usually when assignment is forbidden, it'll usually be written in the assignment contract. All these different things that it talks about, right? But like I said, I ain't gonna go into all of it. I just wanted to talk a little bit about some of the terms of how assignments work. Now, all right. Let me see. Real quick. See, what y'all got to realize is that let me see. See, when you're not performing, right? When you're not performing, then it's assumed and presumed that the office is vacant. You know, is your office vacant or are you in office? When you turn 18, did you step in the office or you lost at sea? All right, so we're gonna pull something up, man. I'm gonna pull something up real quick. All right, let's show you something, right? In this section, the term action includes an agency action as defined under 55113, and the term function or duty means any function or duty of an applicable office that is established by statute and is required by statute to be performed by the applicable officer. And only that officer. Damn, that sounds like the Social Security number. Man, boy, I ain't playing. Boy, I promise you when I read that, that's what I see. Because that's the way that they say it when you got social. Only you supposed to be using it. You're the only one that's authorized to sign, to approve, to give anybody the right to use it. You just don't see it as an office and that you're managing an office. You see it as your legal identity. But if you really pay attention, man, you realize what it is, right? It is established by regulation. Then they created by birth registration, statutory law, and is required by such regulation to be performed by an applicable officer, what we call default. When they say, when you fail to perform, when you fail to do your duty, what do you think they're talking about? So you are an officer, right? You're an officer. You just don't know you're an officer. Your God didn't make you a taxpayer. So if you're acting as a taxpayer, you're acting in a particular office of the government. That's why they call it a government name, because that name is your government responsibility, right? That is your government. All right. Now, including a function or a duty to which cause and to 1 and 2 apply, and the applicable regulation is in effect at any time during a 180-day period preceding the date on which the vacancy occurs. 180-day period, ain't that usually like somewhere between the 90 days? Like when you get a contract, they usually give you 180 days or something like that before they report it to the credit bureau, right? Ain't that how it go? They usually 180 days out. They report it to the credit bureau for default, right? Come on now. Unless the officer or the employee, don't you got a Social Security number? Don't they call that an employee's identification number? Huh? So you are an employee of an office. in your name. You have an office. You are an officer. You are an authorized personnel who is authorized to use an office, and only you can use it. You are the only one that's authorized to use any information from that office, right? Is performing the functions and the duties in accordance with all these sections if an officer of an executive agency, including an executive office of the president and any other government accountability office whose appointment to the office is required to be made by the president by and which the advice and the consent of the Senate dies, regions, or otherwise is unable to perform functions and duties of the office shall remain vacant. And in case of an office other than an office of an head of an executive agency, right, including the president and any other government accountability office, only the head of such executive agency may perform any functions or duties of such office. You know what this means? This falls in. Let me show you. Let me show you. Right. Let me show you. I'm gonna show you how you understand this shit. Right. Watch this. Now I'm gonna show you something. Right. Now let me go back here. Right. So right here, it's saying we're talking about an executive agency because our name is a government name. So it's a government agency. It's an executive agency. And that's why we call it our government, right? Executive agency may perform. So only the head or only the one that's authorized to use that agency is authorized to act for it. So you are the only one authorized to act for it, right? To perform any duties for it, right? And that falls in accordance with right here, right? This falls in accordance with capacity in public offices, right? When we dealing with civil rules of procedure, remember a real party in interest, right? The real party is the officer using the entity, the agency, right? Designated in general. An action must be persecuted in the name of the real party in interest, and the following may sue in their own names without joining the person for whom the benefit for whose benefit the action is brought. So what it's saying is whenever they sue or bring a suit against your property or against your name or information, it's saying that you can join in the action. It's saying that you can persecute, bring a suit as a plaintiff in the same action and sue in your own name without actually joining in to the matter at hand. Right? Now look, joined of the real party in interest. The court may not dismiss an action for failure to prosecute in the name of the real party in interest until after objection. A reasonable time has been allowed for the real party in interest to ratify, join, or to be substituted in the action. So when you don't join, when they send you a summons is a request to participate in the proceedings. It's an offer to be added in as a plaintiff in the matter in order to assert any rights of interest that you have. When you don't join in, you automatically default because they're supposed to be a plaintiff or the defendant according to the law. If they're suing you and they're suing you in your legal name, the law requires that an action be brought in the real name of the true party of interest. So when you sue, you're not, if they're suing you in your legal government name in all caps, then you, as the real party in interest, is supposed to join in and sue in your real name without joining in on the action as a party having a substantial interest, right? Now, the capacity to sue or to be sued is determined as follows. For an individual who is not acting in a representative capacity, the law of the individual's domicile. For a corporation, see, they telling you, see, you got the rights to sue, or a partnership, or a minor. So all these individuals in whatever capacity, when you appear, you got to appear as the true party of interest. So basically, whenever they sue you as a legal person, you got to bring the suit. You got to be the one managing the suit because the law requires that whoever the real party of interest is or the defendant that's being sued, that you hold the lawsuit. The lawsuit has to be brung by the true party of interest. It can't be brung by the prosecutor. The prosecutor is not the real party of interest for that defendant. He's not the authorized person. He's bringing the lawsuit, but he's bringing it in order to ask for relief, but he's asking for release from you. He's asking for you to join and to grant relief to anybody that's injured by the record. So when you don't join in, then automatically they add you in as the defendant because you and the defendant are persons of interest. So either you make a claim or you become liable. Either which way, right? Let me see something real quick before I get out of here. That's it. All right, so let me get back. Where was I? I got so much stuff open right now. Let me see. Okay, so all right, let me see real quick. Y'all give me a second. Close some of these windows out. All right, so you got Rule 17, you got Rule 19, right? And Rule 19, persons required to be joined if feasible. So how do you know if you're required to be joined into a court case? Usually if you're required to be added into the case as a plaintiff or as a party having an interest, they usually summons you. They usually send out a summons to the true party of interest and they make a request for your appearance in the case. That's your ability to accept and appear and claim any interest substantially involved in the case. If you don't do that, then that's a default. So a person who is subject to service of process, whose joinder will not deprive the court of the subject matter jurisdiction, must be joined as a party. So if your name is already charged as the defendant in the case, and then they serve you, right, and you receive a summons, that's because you are another party, and what they're trying to do is give you a chance to appear without joining in the matter as the defendant by you making your appearance. In that person's absence, the court cannot accord complete relief amongst the existing parties. So if you don't show up, they can't really give relief because the true party of interest for that specific person who has the authority to control it, to sign on his behalf, to issue orders on his behalf, has not joined into the court case yet. All right. So now we got a plaintiff that is not the true party of interest for the defendant bringing the claim against the defendant. No plaintiff should bring a claim against the defendant unless they are the true party of interest. It got to be filed in the name of the true party of interest. The prosecutor cannot file a case in your name because he's not the true party in interest of that account. So when he does that, he's giving you an opportunity to join in. That's why he got to summons you, because he can't bring a charge against your account without notifying you of the charges. So when he notifies you of the charges, that's your chance to intervene or to object or to raise any claims. Okay? Trust me. As a practical matter, impaired and impede the person's ability to protect the interest, leaving existing parties subject to substantial risk of incurring double, multiple, or otherwise inconsistent obligations because of the interest. All right. If the person has not been joined as required because they summons you and it's a requirement that you join in, the court must order that the person be made a party. So when you don't join, they automatically make you a party. And a person who refuses to join as a plaintiff, so what is it telling us in Rule 19? It's telling us that we're supposed to join as plaintiffs. We are the true party of interest. When we join in as a plaintiff. We make a motion to intervene like a third party intervener. You're coming in as an intervener, right, to make a claim of interest, right, as a plaintiff against the defendant, right? So either you're going to be made a plaintiff, see, a person who refused to join as a plaintiff. So it's telling you right away that they're not telling you to join as a defendant. You're not no damn defendant. The defendant is the U.S. person or the individual or the LLC or the corporation or the entity that's being charged in the matter, right? You are the one using that person, identifying under that person, all right? And if you don't join in as a competent man or woman, understanding your rights, you may be made either a defendant or in the proper case, an involuntary plaintiff. So to where they bringing you in and they saying, well, we're going to do this and we're going to do that. And the state saying this. And so in the background, they getting your consent to authorize all the orders. When the judge issues an order and say, we coming back to court on January the 1st and this, and you sit there and you be quiet and you don't say nothing, that's voluntary consent because you are the actual party that has the authority to approve everything. They need your approval because you're the real plaintiff. You're the real party of interest. So they need your consent. They need you to consent or to agree or to stand silent. See, as the plaintiff, you get set up. As the defendant, you get liability. So you gotta change the way you're doing things. If a joined party objects to the venue and the joinder will make the venue improper, the court must dismiss that party. So that means that you can join into the case and make an appearance to be added in as a party having a interest, an ownership interest, or a right in attaching any documents that solidify the right of ownership and request to be joined in, and then you can dispute the jurisdiction as improper. When joinder is not feasible, if a person is required to be joined, if feasible, cannot be joined, the court must determine whether in equity and in good conscience, the action should proceed amongst the existing parties or should be dismissed. All right. The factors for the court to consider include, so this don't just go for us, this also go for the state. Like when the state is supposed to be in the hearing, are they supposed to be there? And they're not there, then they can decide whether or not they want to continue without the person being there or dismiss the matter. Because if you don't show up, it's a default. So it's the exact same thing with them. But let me get up out of there. I just wanted to show y'all that, right? So let's get back on this, right? Real quick before I go. So I think you're ready to get away from this, right? So what do we learn from this? The assigner is the person transferring contractual rights, carries certain legal responsibilities when making an assignment. He cannot casually assign the same interests multiple times or transfer rights he does not actually have without facing liability. To protect assignees, the law recognizes assigners' warranties. Unless the contract explicitly provides otherwise, when a right is assigned for value, right, and not as a gift. So that means that when a right is assigned for value, a right is assigned for value is when you express that you're assigning that instrument against your rights to receive payment and not just giving it away as a gift. And the assigner implicitly promises, one, that the assignment is valid. So when you do the assignment, you got to say that I, John Henry Doe, hereby certify under the penalty of perjury that I am the lawful officer selected under this contract to participate in this installment loan agreement. Number two, I certify that the assignment is valid for all purposes as stated in the assignment, and that I have the rights as the officer to assign this contract for my personal family and household benefit, right? And that I know of no claims or third party liens against the contract. And then you assign it. That's the other person who receives it clear of any defects, of any claims, of any liens, freely transferred from you to them. The rights that you receive from the lender, you're giving to them, and now they have the rights to collect that right that the lender gave you from the lender, which will automatically consummate the contract, because the lender usually gets off the hook without actually lending what he promised. He promised rents, and then we default, and he ain't never got to pay no damn rent. He promised installments. We default. He ain't never got to pay no installments. He promised us personal loan due balances on the, and we default. We never receive one of the balances that we got approved for, because we don't know how to enter into a contract. So the lender getting off, his obligation keep getting set aside. Set aside. Every time you default, they set his obligation aside. And now you're sitting in his place. Now you're acting like the lender. Now you got to be the one paying everybody because you took the lender's place. You took his contract and you became liable as the new lender because you took title over the property. And this is how a lot of this stuff is performed, man. But I think I'm gonna stop right here. Y'all can go check this out on your own leisure. Here go to where it's at. You can just go look this up. 13.1 assignment of contract rights. So learning objective, just something for you to study to help you get a better understanding of, contracts, agreements. You got to get stuff like this. You got to read it, study it, look up some of the laws, and all these different things to get a better understanding of what contractual rights are. You know what I'm saying? Because all contracts provide you with a right and a remedy. And when you start understanding what your contractual rights and remedies are, you can start benefiting in every contract as long as you read the contracts. And like I said, if you didn't show up for the class or the webinar we had that just passed, you missed out on a lot of great information. Now we're going into the second phase of that, where we do actual application, where I show how to actually process items, what you do, how you actually deliver the items, and what you put on certain items, and how you create certain items from scratch in using these items for your benefit. So this will be the actual application process to where each person will bring a contract. And then from that contract, we're going to create a payment in order to process the payment, showing them how you read and how you process payments based off what the contract provides. And learning how to read and fulfill your obligation is critical. So that's the second phase of our webinar. We'll be going over that. If you didn't sign up, you missed out on some great information, man. A lot of y'all cheat yourself because y'all play yourself cheap. Y'all don't want to invest in yourself, man. I can't make you believe in that you should come and you should participate so that you can get certain information, because information is the most important element. Once you get it and you got it, nobody can take it away. Just like this learning objective right here that's on the board, right? It once you got it and you start reading it and you start understanding what roles are, who playing what role in here, and when you're reading it, it's gonna help you understand contracts a little bit better, because now you understand how the roles go. See, but if you don't understand who the obligor is, who the obligee is, who the assignee is, then you know what I'm saying? And it's mighty funny that a lot of people don't get it. All right, y'all. So I'm gonna go ahead and get on up out of here. I appreciate y'all tapping in. Yeah, I just wanted to cover a couple of things. I ain't trying to make too much noise. Uh, I'm staying right where I've been at: assignment of contracts, uh, security interests, and uh, performance. Performance, duty and performance is where I'm at with this. All right. So I'm gonna be really nailing that, putting a nail in the coffin on that. So I'll be doing a lot more videos pertaining to assignment of contracts, explaining more about assignments, explaining them more about contractual rights, value, consideration, and things like that to help you better understand. Next time I come, I might go into let's see, in fact, let's see. I'm let me see. I might be able to do a little something real quick. I got a little time. Y'all want me to go in a little bit more? Let me see in the comments. Who want Brother Isaiah to go a little bit deeper? Y'all want me to keep going? Or y'all want me to go and get off? Let me see. How many people want Brother Isaiah to keep dropping the signs? If you want me to keep dropping the signs, I'll go into this next one. If not, I'm gonna get up off here. Let me see. Y'all ain't got no comments for me? Okay, I see where brother said go in. Hands up. It's 21. It's 21 of y'all on here. We here? So it's only two. It's only two of y'all. It's only two of y'all that want me to go in. That's all. That's it. Y'all, I got 21 of y'all on here, and that's all I got. It's all y'all playing, man. Y'all can't want the. Y'all don't really want the information for real, do? Huh? Let's go in. All right. Okay. Let's see what we got. Okay. 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 So this is the Contract Act, 1872. All right. In the interpretation clause, it says, in this act, the following words and expressions are used in the following sense, unless the contrary intention appears from the context. When one person signifies to another his willingness to do or to abstain from doing anything. All right. So when the lender extends a loan or credit, he's either extending credit to you or he's either withholding credit from you. It's one or the other. Okay. And in either which way, he's trying to get your assent to that act or the abstinence. He is said to make a proposal. So if he proposes not doing something and you accept him not doing it, then you accept non-payment of the proposal. So if he proposes an amount that's due to you for the month, but he doesn't actually make that amount or apply that amount to where it's showing that the amount is being reduced for the month from the loan that you got approved for, and you don't object and demand payment, then you just assent it to non-payment because you accepted a notice of a withholding of amounts that are due to you without claiming, all right, without demanding that they be paid, right? When a person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. So if you receive a proposal from a lender and you sign it, then it's accepted, whether it's a mortgage, whether it's a lease, whether it's a license, whether it's a bill, whether it's an invoice, it don't matter what it is. A proposal accepted when assent is given. A proposal when accepted becomes a promise. So if I sign a mortgage, it becomes my promise to pay the amounts that the mortgage is providing. If I sign a lease, it becomes my promise to pay the rents that the lease is providing. If I sign a bill, it's my promise to pay the amounts that the bill is providing. It becomes a promise. Anything you sign becomes a promise, right? And the person making the proposal is called the promisor. And the person accepting the proposal is called the promisee. So the lender is the promisor. So he owes whatever he's promised. And the promisee is the one who is borrowing the promise what the lender is promising. So the lender is promising goods, and the borrower is the promisee of the goods the lender promised under the agreement. When at the desire of the promiser, the lender, the promisee or any other person has done or abstained from doing. So either you do it, either they do it, or you do it. Or either you don't do it, or you abstain from doing it. Or he does or obtains from doing, or promises to do, or obtain from doing something, such act or abstinence or promise is called consideration for the promise. So your original promise was the contract. And any other thing you do in reference to what you said you was going to do becomes your consideration. So if you give a promise, that's consideration, right? Or if you do any act inconsistent with the promise you made, that is considered as your consideration for the promise. And every promise and every set of promises forming a consideration for each other is an agreement. So if I got one invoice and you paid it with cash, then next month I got another invoice and you paid it with cash, and then next month I got another invoice and you paid it with cash, that becomes the promise. That becomes your promises for all the promises you made. So you made a promise to pay me, and all your promises are being given as consideration in cash. So you pay me in cash in order to fulfill your promise. And all those payments together form the consideration. So if you was to tell me to validate the debt, I'm gonna send you all invoices. Why? Because the invoices is our contract. That is our agreement. That was what the agreement. You agreed to do something, and then as consideration, you start paying me in cash. So all the cash payments is the consideration of your promise made to me. And if I was to sue you, that'll be the documents that I use. I'll be like, this is proof that this is the consideration and this is our agreement. He agreed to pay me cash. And I have proof of invoices that are paid showing that he agreed to pay me in cash. See what I'm saying? And that creates the promises. A promise which from the consideration or part of the consideration for each other are called reciprocal promises, right? So if my promise is based on his promise and I draw my payment on the promise he made to me, that's a reciprocal promise, meaning that I'm not paying outside of the promise that was made to me. He promised me goods and I promised to pay using the same goods that was promised to me. So I'm using my promise to draw on what he promised. So if I pay, I'm paying off the promise he made to me of the amounts he extended. I'm not paying in no other form of payment. I'm only giving what was promised to me in the agreement back to him, right? An agreement that is enforceable by law is a contract. An agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of others is a voidable contract. A contract which ceased to be enforceable by law becomes void when it ceased to be enforceable. All right. Now, this part right here is very important. Why? Because in all contracts, you need to know what a communication is. You need to know what a proposal is. You need to know what acceptance of a proposal is. You need to know what a revocation of a proposal is. And you need to know in detail what they are, because when you do something, you might think that, oh man, I did this and they just ignored it. Well, according to the contract law, once you sent it to them, that is considered as a proposal, right? It's considered as complete once you do it. See, and it tells you right here, a communication when complete. Communication of a proposal is complete when it becomes to the knowledge of the person to whom it is made. So once you receive the bill, it's complete. The communication of the acceptance is complete against the proposer when it is put in the course of transmission to him. So at it be out of the power of the acceptor as against the acceptor when it comes to the knowledge of the proposal. So it's telling you, when you accept the proposal, you send back your acceptance through the mail. You letting them know, hey, I received the bill stating that the total amount due for the month of $250,000 for my personal account. As the registered owner and payee of this T-Mobile account, I accept your monthly payment for the $250. And as consideration, I hereby provide you with my banking and routing information for you to direct the disposition of all funds payable to me directly into my checking account. That's an acceptance of a proposal, okay? It's when you can accept and do a disposition, okay? All right, the communication of a revocation is complete as against the person who makes it when it's put in the course of transmission to the person to whom it is made. So if I rescind a contract, if I cancel a contract, it's considered as complete once I put it in the mail. All right? I ain't got to argue with the company saying that I sent the rescission. All I got to do now is know how to file my suits, know how to complete my administrative process, knowing that what I've done is completed. How do I know it? Because I'm reading the Contract Act, and I'm not going by what I'm guessing. I'm going by what this act tells me when I communicate or of a revocation, when I say I'm revoking something. All right, it's complete once I put it in the mail. A revocation of a proposal and acceptance. A proposal may be revoked at any time before the communication of its acceptance is complete as against the proposal, but not afterward. An acceptance may be revoked at any time before the communication of an acceptance is complete as against the acceptor, but not afterward. Revocation how made. A proposal is revoked by communication of a notice of revocation by the proposer to the other party by the lapse of the time prescribed in such proposal for its acceptance, if or no time is prescribed by the lapse of a reasonable time without communication of an acceptance. So it's telling you that, all right, you can accept somebody's proposal by letting the time lapse that you have to communicate or to say something. If you don't say something, if you don't communicate within the specified time frame, then it's considered as an accepted proposal, or it's considered as an unaccepted proposal. So if the creditor proposes something to you, giving you a right to accept the proposal for your benefit in which you applied for, and you don't accept the proposal when it's presented, it goes unaccepted. An unaccepted proposal is an unfulfilled obligation, meaning non-payment, meaning payment doesn't happen because it was never accepted. So it becomes outstanding. Okay? You got to know that. And then when you go in here and you read the Contract Act, it don't say that an acceptance is paid to the order of assign my rights to this. It don't say that that's what an acceptance is. Nowhere in here does it say pay to the order of credit the same. It don't say none of that shit about an acceptance. Nowhere in here. Nowhere in here does it say that. It says acceptance must be absolute. In other words, to convert a proposal into a promise, the acceptance must. So what are you doing? You're converting. You're converting? Convert? Am I reading this right? It's saying that you're converting a proposal. What is a proposal? It's a contract, an agreement. You're converting a proposal into a promise. The acceptance must be absolute and unqualified, right? It must be expressed in some usual, reasonable manner, like in words written, unless the proposer prescribes the manner in which it is to be accepted. If the proposal prescribes a manner in which it is to be accepted, the acceptance is not made in such manner, the proposer may, within a reasonable time after the acceptance is communicated to him, insist that the proposal shall be accepted in the prescribed manner and not otherwise. But if he fails to do so, he accepts the acceptance by performing conditions or receiving consideration. performing of conditions of proposals for acceptance of any consideration for a reciprocal promise which may be offered with a proposal is an acceptance of the proposal. So what is it telling you? If you receive a proposal from a lender of an amount due, right? It's saying right here, performance of the conditions of the proposal. So if the proposal is $255, is due on the 15th, and you sign it, that becomes a promissory note. And for the acceptance of the consideration for a reciprocal promise, which may be offered with the proposal. So it's telling you, you can offer with the proposal that you accept a reciprocal promise. You can accept that, and that becomes a promissory note, and then you can send it back with a reciprocal promise to pay it. It is an acceptance of the proposal. An acceptance of the proposal is any reciprocal promise that extinguishes the proposal accepted. So if you accept and promise to pay $250 and you tender $250 along with the accepted item, it's paid. It's paid. Promises, expressed and implied, insofar as proposal or acceptance of any promise is made in words. The promise is said to be expressed. And insofar as a promise or an acceptance is made otherwise than in words, the promise is said to be an implied. So if you receive an obligation on a contract and you don't say nothing when you receive the bills, the statements, the invoices, then it's an implied acceptance, meaning you accept it by operation of law, meaning by law merchant, the law automatically operates against you to perform the duty of what you're accepting, meaning that the lender is offering things to you for you to use, to pay with, and if you don't accept and express your rights to use them, then it becomes an implied promise that you are implying by performance of the way you're performing, that you are promising to pay it by performing it. That's an implied performance. Implied performance is when you don't express any other way to perform outside of performance of the agreement. So you just perform. Every month you just pay. However you got to make that payment, you just make it. That's an implied promise, because if you were paying in any other form or any other way, you express it as acceptance, right? Now, let me read this real quick. What agreements are contracts? All agreements are contracts. So an agreement is a contract if they are made by the free consent of the parties competent to contract for lawful consideration and with lawful objection, and are hereby expressly declared to be void. Nothing herein contained shall affect in law, in force in India, and not hereby expressly repealed, by which any contract is required to be made in writing or in the presence of witnesses, or any law relating to registration of documents. This little part right here is powerful if you understand what it's saying. This is powerful right here, all right? Because it's telling you nothing here contained shall affect the law in India or expressly repealed, by which a contract is required to be made in writing. So, now let me ask you a question. How are you in a contract with the lender if you never made a contract in writing with him? If the contract that you signed was made by the lender, how are you in a contract if, according to what I'm reading right here, it says, by which a contract is required to be made in writing or in the presence of witnesses or any law relating to the registration of documents? So it's saying that when you get a document that's been approved, in order to make it a contract, you got to do something. You think you in a contract. You've been thinking this whole time that you in a contract, but according to my understanding, a contract is required to be in writing, and usually some witnesses that witnesses the contract. It's called a meeting of the minds. So if you haven't made a meeting of the minds, then you're not in a contract. You're in an accepted offer or an accepted credit agreement, but it hasn't turned into a contract. Who are competent to contract? Every person is competent to contract who is of the legal age of majority according to the law in which he is subject, and who is of sound mind, and is not disqualified from contracting by the law which he is subject. What is sound mind for the purposes of contract? A person is said to be of sound mind for the purposes of making a contract if at the time when he makes it, he is capable of what? Understanding it and of forming a rational judgment as to its effects upon his interest. What? What? So that means that if you don't understand interest, you're going to default every time you sign a contract because you don't know what you're actually applying for. You don't know what you're actually requesting. And when it's approved, you never use what's yours because you never knew what you were trying to get. You're incompetent. You don't understand it. You don't even understand self. That's why you can't understand interest, because the spirit is the interest of the body. And you're not aware that you are the true party of interest. That's why when you go to court, you go in as the flesh. You don't come in as a party of interest making the claim over the person because you're incompetent and you're not able to realize and recognize your property and contracts because you don't understand how interest works because you're unaware of your own interests. Right? But I'm finna get on up out of here, y'all. That's it for now. I ain't gonna go no deeper. Let me say a few words before I go. Okay? Let me stop this real quick. Right? Sweet. How do you do it? Okay. So I just wanted to let you know, man, that you gotta start reading contract law. All right. Everything in the system is based off contracts. Contracts is how all agreements are started, and any rights pertaining to any goods it's all backed by a contract. The contract is pretty much the security agreement that secures the rights of the lender and the rights of the borrower in the same agreement. You know what I'm saying? So learning how to read your contract and learning how to enforce your rights under that contract is how you get your benefits. Understanding what you're receiving, understanding why you have to put in the application and why the application has to be put in, right? Usually when you're trying to purchase something of value, you got to actually put in an application for it, right? Because you're purchasing something of value, something to use, something to benefit from. And it's usually a requirement that it be applied for. And once it's applied for and it's issued, then you have the rights to purchase. Now, when you buy something, you got to understand that you don't just buy with cash. See, we only used to using cash, checks, money orders to buy things. We're not used to buying products with our signature. You're not used to that. Nobody never told you bought a lease when you signed it. Nobody never told you bought the installment contract at the time when you signed it, because it was a transfer of a title. And when you signed it, you accepted the title as your title. That's a purchase. When you buy something, you buy it by purchase. You can buy things just by purchasing them. All right, a buyer of accounts. When you buy an account, you don't actually pay cash for it. It's issued to you as an OID, an original issue discount, meaning they don't charge you to purchase the accounts. They issue them to you at a discount, meaning all you have to do is purchase and pay for it with the value that's extended with the purchase, if you understand what the purchase agreement is. Hey, and with that said, man, I'm gonna get on up out of here. If you want to learn more about anything that I've been going over, things like that, you know how to reach me. You know how to go to buildingbetterminds.info. You can purchase any services on the website. You can get a consultation. You get a one-on-one with me, man. You can get whatever you need in order for you to learn. The thing is to get the information directly from the source. So when you want to know something about anything that I'm teaching, you don't want to just keep watching the video. You don't want to just keep watching the videos trying to put the pieces together. I know you be thinking you might have it, but you might be missing a lot of different things, because when I talk, I speak in a way for you to comprehend. Like I might say, when you purchase a lease, you're purchasing rents. The lease is a check of rents, meaning that the lease is an item that comes with rents. You didn't owe rents until you bought the lease, but you didn't know you were buying rents through a lease. You didn't know that. So when you hear me say that, you be like, damn, that makes sense. It make a lot of sense, but application is totally different. So being able to make that applicable is something totally different than how it sounds, because I can make a lot of things sound good just by me saying certain stuff, and you hear you, dang, that make a lot of sense. But knowing the correct application, how to apply the information, how to enforce the agreement is something totally different. Because if it was really just as simple as most people think it is, then everybody would be doing it. And it wouldn't be we wouldn't even have to talk about it. Everybody already know how to do all this stuff, because it's been out for years about assignment of rights and all this stuff. But a lot of people still ain't getting no remedy because they still don't know the proper way to do stuff. They don't know all the ins and outs that's required in order to be substantiated for you to do what you're trying to do. All right. So that's why I say, once you know that you have a person who has the right take on the information, and they're not able to just talk it, but actually show you through different codes, statutes, acts, certain information to show that what they're saying is true and correct, and that it lines up with other things that they're showing you, then that shows you right then and there that that person is not just talking. He's showing you application. I'm proving it to you that everything that I'm saying is true and correct, right? I'm going to show y'all one thing before I go. I ain't going to tell you where it's at, but I'm just going to show it to you just so you can see. All right? Because y'all don't believe that Brother Isaiah got that heat. Well, let me show you. Let me show you real quick that I got this heat over here. Let me show you. Let's see. I'm going to pull up something real juicy for y'all. Real juicy. Real juicy. This is a good one, too. I ain't gonna do that's too much information right there. All right. Nah, hold up. I'm almost there, y'all. Give me a little time. I gotta make sure I get the right one. I got a lot of.
One is to represent yourself.
All right, let me read something for you. This called identification requirements, right? Now it says, in person, an individual should be prepared to identify himself or herself by signature, i.e., to note by signature the date of access, social security number, and to produce one photographic form of identification, driver's license, employee identification, annuitant card, passport. If the individual is unable to produce adequate identification, the individual must sign a statement asserting his or her identity and acknowledging that knowingly or willingly seeking to obtain access to records about another person under false pretense may result in a fine up to $5,000. In addition, depending on the sensitivity of the records, the Privacy Act, officers or record keepers designees, after consulting with the appropriate system manager, may require further reasonable assurance, such as statements of the individual who can attest to the identity of the requester. In writing, a participant shall provide his or her name, date of birth, an account number or social security number, and shall sign the request. Most individuals shall provide the participant's account number or social security number, shall provide a statement of the relationship to the participant unless it is clearly identified in the nature of correspondence, and shall sign the request if request for access is granted by mail and in the option of a Privacy Act officers or keepers of record designee after consulting with the appropriate system manager. The disclosure of records through the mail may result in harm or embarrassment if a person other than the subject individual were to receive the records. A notarized statement of identity or some other similar assurance of identity will be required, right? So basically it's talking about like when you're trying to validate who you are and prove your identity in relation to the information that you're providing to an institution. And it's basically telling you that in so many words, it's saying that your identity has to be validated, right? Uh, yeah, hold up, y'all. Let me see. I'm trying to see something. Hold up. I got a couple of things on here. Give me a second. I gotta bear with me, man, because I'm trying. I got a lot of, I got a lot of, I got a lot of information over here that I gotta filter through to find what I'm looking for. And I just found one, but it's acting like it don't want to load. Hmm, that's crazy. That don't want to load. I'm almost there, y'all. Almost there. Mm. Okay. Ah, yeah, sometimes it take a little minute for me to find what I'm looking for because I got so much information in here I gotta stroll through. But what I'm looking for is something pertaining to. I mean, I'm finding a lot of different things, but it ain't what I'm looking for. Okay, here we go. Check this out. All right, so liability for certain acts, right? In general, subject to paragraph 2, any person who knowingly presents or causes to present a false or fraudulent claim for payment or approval. B, knowingly makes, uses, or causes to be used, or uses a false record or statement of material to a false or fraudulent claim, right? C, conspires to commit a violation of subparagraph A, B, C, D, E, F, or G, has possession, custody, or control of property or money used or to be used by the government, and knowingly delivers or causes to be delivered less than all of that money or property, is authorized to receive or deliver a document certifying receipt of property used or to be used by the government, and intends to defraud the government, makes or delivers the receipt without completely knowing that the information on the receipt is true, knowingly buys or receives as pledge of an obligation or debt public property from an officer or an employee of the government or a member of the armed forces who lawfully may not sell or pledge property, or knowingly makes or uses or causes to be made or use a false record or statement of material to an obligation to pay or to transfer money or property to the government, or knowingly conceals or knowingly and improperly avoids or decreases an obligation to pay or transmit money or other property to the government, is liable to the United States government for civil penalties of not less than $5,000 and not more than 10,000, as adjusted by Federal Civil Penalties Inflation Adjustment Act, right? Plus 3 times the amount of damages which the government sustained because of the acts of that person. And the court finds that the person committing the violation of this section furnishes officials of the United States responsible for investigating false claims, violations with all information known to such person about the violations within 30 days after the date on which the defendant first obtained the information, right? So I ain't gonna read all of it, but in so many words, right? Anybody committing a false claim, right, is liable to the government for any fraudulent or false claims that they make, like with the government. So that's basically what this is talking about. It goes really deep, man. It really breaks it down all the way and stuff like that. But, you know, like I said, I just wanted to read that, just a little piece of it, just to show you that you got to find the right information and things like that. And in here it tells you that the term claim means any request or demand, whether under a contract or otherwise, for money or property, and whether or not the United States has title to the money or the property that is presented to an officer, employee, or an agent of the United States, or is made to a contractor, grantee, or other recipient if the money or the property is to be spent or used on the government's behalf, or to advance a government program or interest in the United States government, provides or has provided any portion of the money or property requested or demanded, or will reimburse such contractor, grantee, or other recipient for any portion of the money or the property which is requested or demanded, and does not include requests, demands for money or property that the government has paid to an individual as compensation for federal employment, or as income subsidiary, with no restrictions on the individual use of the money or the property. The term obligation means an established duty, whether or not fixed, arising from an express or an implied contractual grantor-grantee or licensor-licensee relationship, from a fee-based or similar relationship, from statute or regulation, or from the retention of any overpayment. And the term material means having a natural tendency to influence or be capable of influencing the payment or receipt of money or property, right? So, yeah, but this is definitely what it's talking about. You know, anybody in receipt of money that don't use the money for the purpose in which the money was being granted for is in violation. You can't money launder. You can't take money and use it for other purposes if it was meant to be used for the public. If you receive a public loan or a public debt, you got to pay that to the public. You can't keep that as a private debt because that's a public obligation. And private and public don't mix. So when you start mixing public obligations with your private enterprise, then you become a public charge. That's how you become a public charge, holding public charges that are publicly assigned to the government, and you hold them, you keep them, and then wondering why you got to pay every month because you don't understand what an obligation is. All right, with that said, man, I'm gonna get on up out of here. I'm gonna bring this one to a finalization. Like I said, if you want to learn more, you want to get more in detail, you want to learn where more information is stored, because I got a lot of information I'm not putting out. Because if I put it out, it'd just be like just giving away all the answers. You know, it'd be like just giving people stuff that they never had to work or acquire. You know, they ain't have to do nothing to get it. You know what I'm saying? So that's why I put it out the way I put it out. You're gonna have to dig. You're gonna have to dig a little. I give you enough information for you to put the pieces together so you can figure out what you need to be doing. But a lot of this is going to be based off this. Have you read enough? Have you studied enough for this information to resonate with you? Because you can't enforce nothing you don't understand. You can't do something you don't understand for real. And it takes time for you to understand certain aspects of what's going on. But I can tell you right now that the system that we live in is actually magnificent. It's actually a very great system. And actually, nobody's even putting you in debt. You're putting yourself in bondage because you refuse to learn the system. You refuse to understand what the documents are. You know, you open up an account, and every account you open up, they billing you. And you still ain't trying to figure out what bills are. You still ain't did no homework to understand what's actually taking place. You don't understand what an amount due. You still ain't did no homework on it. You still don't know what it means. So when you don't understand what things mean, you ain't gonna never do what's right. You're gonna keep following what everybody else does. You're gonna do what monkey see, monkey do. So you're gonna end up doing what everybody else do. Why? Because that's what most human beings do. They follow and mimic everything that they see. And that's why so many people is what? Doing the exact same stuff. Because we all following each other. We all, oh, he did, I'm going down and get mine tomorrow. Yeah, man, she did. Yeah, man, I'm gonna get me one. Ain't nobody talking about reading no laws. Ain't nobody talking about reading no code, no statutes, no nothing. We just going to do. Go right now, let me get an application. Don't read no instructions, don't read no fine print. And then we wonder why we in the situation. We think we the smartest people in the world too. You can't tell one indigenous Aboriginal person, because we ain't gonna call ourselves Aboriginal. You can't find one Aboriginal person, Asiatic, right, that actually be wanting to read the fine print. We don't want to read nothing. I don't want to read nothing, man. Most people I talk to and I tell them, I say, they be like, hey, Brother Isaiah, I'm trying to do this and do this. I told him, I said, you read your contract? Yeah, I read a little bit of it. Did you see the holder in due course rule in your contract? That's the first thing you're supposed to be looking for. You're supposed to be looking for all the required disclosures, the truth in lending disclosure, right? The rights to rescind. You're supposed to be looking for the cosigner, deceptive cosigner practices. Notice. Let me show you real quick. Let me show you. All right, because the key thing is for you to know what disclosures the creditor is required to give you, right? So a lender, right? He's in the business of lending money to consumers within the jurisdiction of the Federal Trade Commission. So if you're dealing with a lender, you're in federal jurisdiction. Why? Because the Federal Trade Commission is in federal jurisdiction. Okay? That's federal jurisdiction. So if you're receiving money from a lender in the Federal Trade Commission, meaning if you're trading securities, buying and selling, you're in the Federal Trade Commission. You're in federal district. You can only buy, sell, and trade in federal district. It's illegal to buy, sell, and trade in America. You cannot buy, sell, and trade in America. A lender cannot sell you a loan because a lender is not in the business of selling loans. He has to lend and offer that loan to you, right? A retail installment seller, right? They call him a seller because he's selling the contract to you, right? And a person, right, is an individual. So you should be protecting your individual. Your individual is your person. Your person is your corporation. Your corporation or it's in a business organization. That's why you can do a DBA for your individual without getting the EIN, because it's already a business organization. It's an individual business organization. And you are the sole user and owner of the individual account that you're using. The consumer. It ain't making no mistake. A person is not a consumer. A consumer is a natural person who seeks or acquires goods or services for money, for personal, profit, family, or household purpose. So how does the consumer acquire goods for his personal, family, or household use? Right here. He uses an individual, corporation, or business organization to do it. So if somebody's charging you for the individual obligations of your person, that's an adverse action because you are the creditor for the individual person. And for them to be making you liable for your person, that's an adverse. That means that they did deception against you. They didn't tell you that you were acting for a company. They hid the truth from it. But I'm gonna show you today so you'll know the truth. All right, obligation is an agreement between a consumer and a lender or a retail installment seller. And the creditor is always going to be the lenders because the obligation is due to the creditor. I mean, he owes the money. All right, the debt is money that is due or alleged to become due from one to another. So the money was due to you at the time you signed the debt. When you gave it back to the lender, you was expecting that the amount that you signed to that was due is actually received on the due dates, not collected, but actually received because it was extended as credit. But the lender is the reason why you're not receiving it because he's tricking you, right? Now, compensation, look at this. Is compensation paid or payable to an individual? See? So they pay it to the individual, the account. So whenever it's paid to an individual or for his or her account, see, for personal services rendered or to be rendered by him or her. So who's the service provider? Is it T-Mobile? Is it the gas company? Is it the water company? Or is it you, the man or a woman, supplying services on behalf of the individual person? Meaning that the individual can't receive any services until you approve them, until you sign. You are the authority for that person to receive services. Any service, any other person provides you with the service agreement, and you are the one who approves it. You are the one who issues it for the person. And they misrepresent as if it's them, but it's really you. You are the service provider for the person. You are the only one that can provide services under that name. You're the only one who can sign under that name. You're the only one that can transfer records under that name. You are the service provider. Okay? So whether denominated as wages, salaries, commission, bonus, or otherwise, including periodic payments pursuant to a pension or a retirement or disability plan, you're supposed to be recognized as the one issuing that for the person, right? Now, household goods, we're going to go past that. We're going to go past antique. We're going to get right here to cosign, right? Right, because this is something that they're supposed to tell you, all right? This is one of the federal disclosures that is required by retail installment sellers and lenders to be in the contract, okay? Trust me, brother Isaiah, I'm putting you on game. A natural person who renders himself or herself liable for the obligations of another person without compensation, right? The term shall include any person whose signature is requested as a condition to granting credit to a U.S. person or as a condition for the forbearance on collection of a U.S. person's obligation that is in default. The term shall not include a spouse whose signature is required on a credit obligation to perfect a security interest pursuant to state law. So when they ask you to get your wife to sign, that's because your interest is not good enough to perfect the agreement. So they need somebody with a better interest rate to perfect the interest so you can get the contract, because it's a contract of interest where you can pay, you're paying in interest. You're not supposed to pay in cash anyway, right? Now it says a person who does not receive goods, services, or money in return for a credit obligation. It didn't say for cash. It says that for credit obligation. What the hell is a credit obligation? It's a debt instrument. It's a contract. So if you don't receive goods, services, if you give the bank a contract and you don't get to do EFTs and ACHs and the bank is making you pay them, you never receive services. You never received anything for giving them that item. They ain't giving you no credit for it. They charging instead of letting you receive credit for the item you provided, right? And it says you do not receive compensation within the meaning of this definition. A person is a cosigner within the meaning of this definition, whether or not he or she is designated as such on the credit obligation. So whether the bank account says you're a cosigner, whether the installment contract says you're a cosigner, whether the loan agreement says you're a cosigner, whether the student application says you're a cosigner, whether the job application says you're a cosigner, you're a goddamn cosigner. You are a cosigner for the government. That's why it's called a government name. It's a name belonging to the government. You only get to use it. And when they say give it back, you got to give it back. You're never supposed to sign your name to be bound as the government obligor, because the government obligor only using your name is because you are the identified creditor for that obligor. So when you step forward and use your information, they can match the records. But you keep assuming liability because you think you are a United States person. You think that you are a government person. You're only acting as that official person. It's an official role. You're acting. Your mama didn't create you no government name. The government took that and made that name because that's the name that the government interacts with the government with. So the government is interacting with its own agencies through its own agency. And you are the one that's authorized to control it. So a notice to the cosigner. You are being asked to guarantee this debt. Think carefully before you do. If the borrower does not pay the debt, you would have to. So who the hell is they talking about? And why I ain't never get this? Huh? Why they ain't never give me that? I ain't never seen this on no installment contract. I ain't never seen this on a sales agreement. Where's my notice at of a cosigner? Huh? They don't want you to know this. They keep trying to tell you it ain't no account. Ain't no such thing as a security account. The consumer fraudulent, sovereign citizen movement. Stop lying. Y'all a bunch of liars. There is an account. And we are the co-signers. Matter of fact, I'm the only one who can sign for Isaiah Bay. Nobody other than me should have their signature on there. If I see Isaiah Bay's name on a contract and a signature on there besides mine, you're in violation. You're not the co-signer for that person. You're not the one to approve his obligations. You're not the one to issue his orders. So you're out of compliance when you do that. That's why a prosecutor should not be suing in your name. He should not be acting as plaintiff over your defendant. That is improper. That is not issued by the true party of interest. All cases must be filed by the real party in interest, meaning you're supposed to be suing the principal, not him. He's not the creditor over that principal. He's not the true party of interest, so he's not supposed to be the plaintiff. Okay? I'm putting you on game because, man, listen, you got to really study to get this, man. Some of this stuff, some of y'all probably have never learned it in a lifetime. I'm going to be real with you because you got to be there in order to get it, right? So this is the notice federal law requires that they give to you. When you get an installment contract, an installment loan contract, if you got an installment loan contract right now and they charging you or they trying to take your car, you can rescind it because it is. You can rescind it because of deceptive acts and practices. You can say, I hereby rescind this contract and redeem my ownership back and claim back all my property. I demand that you return to me my original contract with my wet signature, any down payment, any trade-in, and any advance payments I made toward the loan. And upon receiving all my stuff back, I release the car to you. It's at my house. They can't return it. They already traded the security. It's already been traded on. They can't return your property. And when they can't return it, you get to keep the property for default. And you can record that. Now, when you record it, it's a right under the law, and the Secretary of State has to transfer a title. Why? Because they defaulted under what? A rescission clause. So at any given time, man, at any given time, right, you can rescind a contract or rescind any rights that you have. See, but if you don't know that you're a co-signer, right? If you don't know that they're not supposed to be making you liable for the debtor's obligations, because the debtor is the United States. Each and every last one of us has a U.S. person. Each one of us has a U.S. account. Each and every last one of us, and where the United States is the account holder. The United States is holding your bank account. The United States is holding your T-Mobile account. The United States is holding your water, your gas, and your electricity account through the U.S. person. How you think they know what you owe? How you think they know whether you in default or not? You know what I'm saying? Come on, man. The lender already approved you, so he ain't the one that should be collecting from you, because he the one that approved you for the government amount. So if you're not receiving that amount, then it must be the government demanding that the lender collect, because the government is saying you defaulted somehow. See, you got to understand what's going on, but the lender used deceptive measures and tactics to trick you. Why? Because the lender wanted you to believe that you were entering into an agreement to pay him. That's considered as money laundering. If you receive public funds, you ain't supposed to be paying that to the lender. You're supposed to be paying that to the government. Those are public funds. Why are you underhandedly on the side having a private agreement with the lender concerning public funds? You're trying to buy public funds without letting the government know what you're trying to purchase. You ain't supposed to be doing that. That's money laundering. That's taking money issued to the benefit of the public and using it for your own selfish means, and not transferring it so that the government can pay off the government debt. Because all debts create a government obligation. And if you don't give the government the obligation, the debt is outstanding and we have a national deficit, because consumers and Americans are incompetent. They ain't allowing the government to pay off the debt. All right, y'all. I'm done. I'm done running my mouth. But like I say, whenever you're ready, you can tap in with me. All right? You already know how to reach me, buildingbetterminds.info. Like I said, my thing is to bring awareness and bring clarity so that you can have a better understanding. I suggest that you tap in with me because you want to learn. This is a learning experience. You need to be in a classroom. You don't need to be just focused on, I just want to get a bill paid. No, you don't want to just do that. What you want to do is learn these laws. You want to learn what contracts are. You want to learn what interest is. You want to learn what ownership rights mean. You want to learn what security interests mean. You want to learn all these different things. And then once you learn these things and you understand what they are, it puts you in a position of power. So now you're able to see your power. You're able to see where you at, and you're able to act within the right capacity in accordance to what the law gives you the rights to do. But before you do that, you got to know the positions. You got to know who the obligor is. You got to know who the promisor is, who the promisee is, who the assigner is, who the assignee is, who the drawee is, who the drawer is, who the payee is. You see what I'm saying? You got to know all of that. And you can't guess. You can't be trying to assume you know what these roles mean. You got to actually know what they mean in order for you to perform. You can't perform with a lack of knowledge. It's impossible. It's impossible. You can't do it. So either you're going to get your head together, you're going to learn, educate yourself, or you're going to get with somebody who can educate you and stop trying to be on the outside looking in. Come in and get the knowledge. Step in and learn. Because once you learn this, what I'm teaching you, man, you're going to be free. You ain't going to have to worry about nothing. Once you start learning how to settle your obligations, once you learn how to read your contracts and know what the contract is saying, when you're able to understand what rights you have, once you're able to sit down to the lender and you can talk to them about the contractual rights in the contract, you can tell the lender what you're trying to do. You can ask him what form of payment would he like. Would you like it by EFT? Would you like it by direct debit? Would you like a wire transfer? Or would you like for me to give you an assignment and allow you to do it on your own? So, once you get the knowledge, you can negotiate. That's why it's called negotiation. Called negotiation. And once you acquire a right, or a right is approved, then you have the rights to do it. You just got to be confident. All right, y'all. I'm out of here. I'll catch y'all in the next one. Thank you for your time. Thank you for your efforts. Like I said, it's your first time tapping in. Make sure you hit the like. Make sure you hit the subscribe button. If you follow me on YouTube, you can subscribe on YouTube. We also got a YouTube membership that if you want to get in, where we got more exclusive videos and things where I go in and more details about different things. And I do got a lot more information I'm about to put up on the YouTube channel where I show applications. So if you want to see like the forms, the documents, how we're going to be presenting them and stuff like that, a lot of that information going to go on the YouTube page to where you can go on there and see how we're going to do it. And a lot of that stuff gets, like a lot of the webinars, I upload them to the YouTube channel for my YouTube members so they get those webinars. Not all of them, but sometimes depending on what it is, I upload it. Like this one that I'm doing now with the negotiable instruments, how to process the payments. This will go on my YouTube page for my YouTube members, for all my supporters that's been supporting me for years and stuff. They deserve this information. They deserve to know the proper ways and the right ways that I've learned to exercise those rights. So I make sure I provide that to them. And I'm not excluding you guys in the public because I appreciate you guys too. Anybody that's on this video, anybody that's supporting, watching, liking, sharing the information. That's why I do what I do. That's why I bring clarity the way I do. A lot of the stuff I'm saying, I don't really have to say. But because I want you to understand that my true intention is to help you. So I want to make sure that I'm not just always trying to charge for anything I do. I want to make sure I give out good, adequate information that helps you get a better understanding. And then hopefully you see my spirit, you see my efforts, and then that makes you want to say, you know what, I'm going to tap in with Brother Isaiah. You know, he didn't prove himself worthy to me. He didn't show me. This man that gave me information that I know he could have charged me for. And that in itself should give you enough information to say, man, you know what, this brother worthy of my time. He worthy of this because he's showing his worthiness. So if you can't appreciate what I'm doing and give me the same in exchange, man, then I don't know what to tell you. Just keep watching the video.
What she need help with?
Oh, Shamika. Where you see that? Shamika, dear God, I need help. What you need help with, sister?
Yeah, see what she need help with.
Huh?
Email us if she don't want to put it out.
If you don't want to put, if you got any concerns or any information that I went over and you want to learn how to properly do some of the stuff that I've been covering, you understand it, but you don't really understand how to take action. Get in contact with me, man. Go to Building Better Mind. Y'all got to get in contact. Stop getting on these lives and videos and saying, how do I do this? And how do I, man, all you got to do is reach out to me. All you got to do is go on there, make a phone call, and reach out. And then when you get on the phone, just tell them what you're trying to do. I need an hour with Brother Isaiah. I seen some on the video he was talking about, and I'm going through a situation similar to that. I just wanted to know if he can assist me with actually going through the process that what he was talking about, because I got something similar to that. That's what I'm doing it for, so I can help you out. But if you don't reach out to me, if all you're going to do is go online and put a text and say, I need your help, or brother this, I don't look at all those. Man, you know how many comments I get on a regular basis? Man, it's hard to go through all of that.
Yeah. If she actually reaches back out, then we can help her pick her.
Yeah. I think I'm gonna do
hey, genius.
I think I'm gonna do a pool, right?
A what?
A pool. Something I'm making up. I'm gonna get everybody. I think we're gonna do something like a raffle.
Well, we already we're having a free webinar coming up.
No, this ain't for a free webinar. I was thinking about doing a raffle where we select one person from the public, and whoever win the raffle, we give them a free one-on-one where we help them settle an obligation that they having issues with. Like say if you're in a mortgage, or you got a car contract or something like that. So, and you need help. So what I'm gonna do is I think I'm gonna do a raffle, and we're gonna allow people to, get into the raffle, and whoever, we might get like 2 or 3 people, and whoever win the raffle, then you'll get a free one-on-one with me where I help you deal with one of your major contracts. Only one contract. So if it's a lease, we'll deal with that. If it's a mortgage, and that, we'll deal with that. If it's any personal contract, bills or something like that, we'll deal with that. But I think I'm gonna do a raffle for it.
All the way through?
What you mean?
You gonna deal with it all the way through all the steps, stages, and degrees?
Oh yeah, we're gonna go through the whole thing. You know what I'm saying?
You're not gonna go through the whole thing.
Yeah, we're gonna go through the whole thing.
All of it.
All of it.
Okay.
From the beginning, we're gonna read the contract.
I'm gonna hold them to that.
We're gonna read the contract. We're gonna make sure that you understand what type of contract you sign and what rights you have. And then once you know all of that, then I'm gonna show you how to enforce those rights, how to redeem that right back from the lender that he took from you. And then you'll be able, once you get that done and asserted, then you can come on and give a testimony. You can go on and tell people, how this information helped you in your situation to deal with whatever you got to deal with. But we're gonna definitely put something together. So y'all look forward to that.
Hey, Maria. So how you want to roll that raffle out?
I don't know yet. I
You might have got off of here.
ain't thought about it yet. But y'all look forward to that. Anybody let's see. I'm trying to see if I can read some of these. Ain't nobody really saying too much of nothing for real.
Yeah. See, I go back up. Is there a way to catch a replay of the first part? Okay. Gemini.
You can reach out to exec assistant at buildingbetterminds.info. It's on our website. If you want to get the first video of the webinar, you can go to anybody that want to purchase the first part of the webinar that we just had concerning processing payments and stuff like that. You can go to Building Better Minds, and then you can email us at our email and inquire about the first part of the webinar. And then you can sign up for the second part if you want to be there, because the second part will be application, us going over the information. That's where you want to be there for real. But it would be a whole lot better if you was at the first one, because it'll help you understand more about what these applications are that we're doing.
Right there.
And a mechanics bond is similar to performance, yeah.
Something like this is done with a title or regular. What is that?
I don't know. I have to look into that.
That was all the questions you had.
Okay, y'all. Well, I looked over most of the questions and stuff. And I see y'all all out of questions and stuff. So I'm gonna go ahead and get on up out here, man. Y'all just go ahead and y'all go over some of the stuff that I showed y'all in this video. Go back and look at some of that material, read it, study it, get a better understanding of it. And if in any way you feel you need my assistance, you need me to go over some things with you, make sure you reach out to me, get in contact with me, man. It ain't hard. I'm not a hard person to reach at all. I ain't like you got to call up different people in my office to get to me. No, you can reach Brother Isaiah. I ain't hard to find. You know what I'm saying? All you got to do is be one of the willing participants that want to actually get something that I offer, and you come and you purchase that product, and I guarantee you we're gonna get you together. Yeah, and I definitely work with people. So, if you are one of them individuals and you need a little work, you need somebody to work with you a little bit on certain things, I can bend to a certain degree. It all depends on the situation and what's going on. But my whole thing is to help you, not to hurt you. My thing is not to put you in debt or put you in bondage. My thing is to take you out of debt and take you out of bondage and prove to you that you was never in debt in the first place, that you was just in a state of not knowing. And that state of not knowing made you feel like you was obligated to pay somebody something that really you never really owed anybody, not in that way. You owe, but not in the way you've been paying. So that's where I come in at, is to help you bring that clarity so that you can learn what rights you have and start enforcing those rights so that you can reap those benefits that the system is basically entitling you to. So with that said, man, I'm gonna get on up out of here. Again, thank you for participating. Thank you for your time. But like all other things, everything good must come to an end. So I'm gonna go ahead and end this live. But I'll catch y'all in the next one. Y'all stay tuned because I got a lot more great information on the way. And if you haven't signed up for the YouTube page or any other things we got going on, make sure you sign up, because the information that I'm going to be putting on YouTube, you're going to want to be a part of it. You ain't going to want to miss it, because this is what people been really waiting on. They've been waiting on application. They've been waiting on me to show you how to actually do what I do and how I do it. And I've been holding it back for a long time because I feel like if I showed everything, then you ain't got to work for nothing. You know what I'm saying? Because I'm already giving you the knowledge. I'm already breaking it down in a way to where you can understand it, to where you can comprehend it. But now that ain't enough for y'all. Just comprehending and understanding it, so now you can understand legalese a little bit. That ain't enough. But a lot of y'all want me to show you how to do it. You can't just go read the acts and stuff that I'm pointing you to that's breaking it down. You still need me to show it to you. So, I decided that I'm going to go ahead and put one together for the people. I'm going to go ahead and just do one little demonstration. And this will be the only time I do it. So make sure you sign up. Don't miss out on this next webinar we got coming up. When is it? Next Sunday? This next Sunday coming up. So I'm going to make sure I put it out there for you so you'll know about it. But, make sure you be there. Meet me there. Don't beat me there. Don't you meet me there. You beat me there. Okay. So on the YouTube page, that's what you're talking about? On YouTube or on the website? All right. So what she's saying is, if you want to be informed of anything that we got going on at the time when we have it going on and you want to get noticed, she's saying go to the website, buildingbetterminds.info, and register on the website so you can have an account on the website. And once you get that account for free on the website, then whenever we send out a mass email about anything that we got going on, you'll be informed through the email of an event with Building Better Minds or anything like that. And you ain't got to be looking online trying to see if you can catch a video and catch me when I'm going live or when I'm having something, because a lot of y'all be missing it because y'all don't know when we actually having it, or you see a video after the fact. So if you want to be informed like everybody else that know about the events and stuff, sign up on our website. It's free. It don't cost you anything. All it costs you is your time and your energy. Sign up, and then whenever we send out notice of anything we doing, you'll be informed. That way you'll never miss nothing. And with that said, I leave you as I always do, in love, truth, peace, freedom, justice, and equality for us all. You guys have a blessed, wonderful day, and I'll catch y'all in the next one. Salute to all my real ones. Peace and love.